welcome everyone. Thank you for joining us today for this webinar on wealth transfer strategies, challenges, and opportunities. For this webinar, I'm going to let our panelists here speak and give you some of their expertise, what they're hearing from clients. They are particularly with the system NetLaw's developed in association with Hargrove Firm. They see a lot of clients from all across the country. And so we're going to talk about some topics that might be pretty traditional topics in an estate planning webinar, wealth transfer planning and execution, for example. But we're also going to be doing so from the perspective of some attorneys that have very diverse and varied experiences in terms of the types of clients they're having these conversations with every day. So without any further ado, I want to quickly introduce our panelists. Samantha started with us over on the online practice recently. She comes to us from Hargrove Firm's traditional sort of sale of business practice, where they help ultra high net worth families and business owners exit their businesses in a tax advantaged way. Don't do the M&A side of the work, but they do all the tax planning side of those exits. So we're really excited to have Samantha's background on the team, and she's working with Kevin. So many of you who may already have worked with Kevin on some engagements may see Samantha or may have already seen Samantha start popping up on engagements with your firm and your clients as well. And then, of course, many of you probably already know Kevin or have had a client with Kevin before that you've met with. Kevin comes to us. He's got a varied background. He has been on your side of the fence on the wealth management side with an RIA, designing plans in-house there. He's worked in corporate trust as well as in private practice. Kevin's been an awesome sort of foundational member of our team here, and excited to have him on with us as well. Of course, given that my perspective, I'm of course the CEO of NetLaw, and you can sort of think of NetLaw as the technology arm of the law firm. NetLaw is a separately owned company, and we've developed technology specifically for Hargrove Firm to scale its practice, and sort of the regulatory environment that lawyers exist in made it necessary to create the technology operations and finance those independently of the law firm. And that's what we've done with NetLaw. So again, being this is I'm on the technology side, I'm going to be biased and start with the technology question. So I want to ask our panelists about how technology has enhanced their practice, and how specifically using the NetLaw platform to deliver the services with Hargrove Firm across all 50 states has changed how they practice law. Why don't we start with you, Samantha? Oh, you're on mute.
Sorry about that. I've noticed that NetLaw's structure of having 3 meetings where clients and advisors are present throughout the planning process really gives the clients more comfort in truly understanding how their finalized plan works. It's a nice flow between the attorney and advisors and clients. The clients get to make some decisions before they come to their next meeting with us, and they really get to understand the information that maybe invokes some questions from them and they're not sure how to proceed. We start with their initial consultation, where we really do an introduction for Hargrove Firm and NetLaw. It allows us to get to know the client's family situation, what their goals are, so we can start to really tailor the strategies for their trust planning at their next plan design meeting. And then at the design meeting, we get to go through all their choices for roles to fill, discuss the importance of that, and the real meat and potatoes of their trust, which is where most of the post-death administration takes place. And then that wrap-up meeting, after they get to review their drafts, it really helps for them to meet with us again, because the drafts contain a lot of information at once. So we get to help them fund and instruct them how to transfer assets into their trust, and they understand what assets have gone into their trust, how everything is simplified in one place, and the process just seems to leave them more empowered to continue to use their plan as it's intended throughout their lifetime. So it's a great process for the clients.
I think that's a great point to highlight too, just the role of the advisor. I talk to a lot of financial advisors, basically my job every day of the week. And the feedback I get is when they refer to a law firm, it's often like a black box. They don't really know what goes on inside. They have to kind of tap on it every few weeks to get some kind of feedback. And I think Sam's right. It's really changed the process for clients, their comfort level. Clients get scared around estate planning. They tend to hesitate, which results in procrastinations and keeps them from actually, getting a basic plan in place. So I think that important role the advisor's playing in facilitating a process and using technology to make sure the advisor is able to not just see inside that box, but actually be an active participant, has been a big game changer. Kevin, what would you say? What features might you say help advisors, facilitate better planning, or at least in the way you've been using it to practice?
Yeah, and you alluded to it with my background, and I'll maybe take a little bit more philosophical approach to the answer. But having been on that side, having sat down with clients and explained estate planning and estate planning strategies and given some suggestions, I'd often always have that, well, great, can you draft the plan for me now? And then have to explain to them, well, no, now you need to find an attorney, and we'll be happy to have a conversation with them. But as you just pointed out, Alex, sometimes that would be a nice collaboration, but oftentimes it would just sort of be my notes getting transferred over to somebody else, and then who knows what they did with it, and maybe they have their own approach to things. So, having the firm be able to use NetLaw to really facilitate and give that experience of a seamless transfer and somewhat of a collaboration, or at least from the client's perspective, it really feels like a collaboration, while also, maintaining everything we need to do to be doing this the right way, crossing all the T's, dotting all the I's, and making sure that, we're giving our independent legal advice, we're providing our independent legal documents and consultation. But from the client's perspective, it does feel really seamless. And that's just been amazing, both when I was on the other side, I wish I could do it, and being able to have those relationships with the advisors now and work through that with the clients. It's great. And then really the second part of it is just the having a team and someone like myself who has comfort level talking with clients all around the country, being able to point out some of those issues where it still happens so often. It seems that, I bring up like, oh, where do your kids live? And invariably it's Massachusetts or New York or Oregon, where there's state estate taxes that the clients themselves furthest thing from their radar because they live in Texas or Florida or whatever it may be. So just really being able to bring that nationwide perspective, that holistic approach. And we're going to talk about this a little bit as we get into the presentation today, but that planning, is impacted what the clients do and what it means for their children and all of that, being able to deliver that pretty seamlessly as well, given our nationwide footprint and our approach to working with the advisors and the planning that we do through the NetLaw portal. So that's the way I see it anyway.
Awesome. Thanks for that perspective, Kevin. And now we'll jump right into looking more at the substantive side of estate planning. By the way, if anybody has questions, there's a Q&A button down there. Feel free to submit those questions by chat. We'll answer either by chat or queue them up at the end of the process. So Sam, turning back over to you now, what would you say are some of the significant challenges advisors face in helping clients plan for those intergenerational transfers that we've been talking about? And how would you say that's evolved in recent years?
Sure, Alex. Well, specifically with more of an uptake of clients choosing to use lifetime protection trusts for their children instead of just giving them outright distributions once they reach a certain age. Now that children know, okay, I'm going to be getting money over the course of my lifetime, and eventually maybe my children's lifetime, if there are enough funds to continue, and if that's the way it's set up, actually getting the children and eventually grandchildren involved to structure their inheritances and create their own estate plan where that's factored in. And it becomes especially important if these children are already old enough and they're in their own structured careers. They potentially are already looking at a taxable estate. And then we get to look, as Kevin already said, the client may not be thinking about state estate taxes or inheritance taxes, but that's just as important when planning for intergenerational wealth transfer so the families can avoid needless taxation. And it is helpful for them to start planning together at the outset. We like to encourage parents to bring their children to their wrap-up meetings if it if it's age appropriate for the children, of course. So that gives a good introduction for children to start learning, okay, this is my lifetime protection trust, learn how the trust is funded, how it's administered, really how it works, and then they can figure out how to structure that into their own planning. And this is also a good place for the advisors to get to meet the children if they haven't already, and that can provide a nice seamless transition for advisors maybe to start working with the children if they don't already, and if not with a specific advisor, then hopefully within that same firm to really keep the comprehensive family planning and for the advisors to have the big picture from the parents down to the children, eventually grandchildren too. So having that comprehensive picture is a real game changer for advisors to be able to help and look well into the future, and maybe even consider some trust and gifting strategies for grandchildren off the bat. So you can really start planning for multiple generations as soon as this client starts.
That's great. And she mentions lifetime protection trust. You know, that's our most popular plan is our advanced plan. These are clients whose assets may not be significant enough to have an estate or gift tax problem, at least not at the federal level, but do have significant assets that they're passing to their kids and want to be sure those are protected from, let's say, a son or daughter-in-law potential divorce situation. Really helpful. Thanks. Now, turning over to Kevin, what sort of wealth transfer strategies are you utilizing in your practice that really go beyond, wills and trusts?
Yeah, and I mean, I'll kind of keep focused on that core element that we really find does a lot of the heavy lifting these days. I mean, we have such a high exemption that just introducing that lifetime protection trust into the mix and helping people put more of a positive spin on it than it maybe have received in the past as just simply a way to, avoid taxes or almost be seen as like punishing the child in a way that they don't get direct access to their funds. But the way we explain it to the clients and hopefully explain it to the next generation over the years is really just that it's going to provide a lot of flexibility to that next generation to be able to do their own planning. So if they do need to address any state estate tax issues in their own world, like we were talking about, this is a way to set it up so that they have that flexibility. Because if you do just provide them all of the assets right up front, this is the can't put the toothpaste back in the tube issue, right? So a lot of times we like to explain it as just let's start here. Let's then build in mechanisms that would give a lot of flexibility to the child to be able to manage that trust in the future. Maybe that means becoming their own trustee at a certain point. We can certainly work with the clients to either create more flexible distribution standards or more defined distribution standards, however it's going to work for their family situation. But at least start with this, wrapper, if you will, where we put it into the protective trust for the next generation, and then give them all of that protection they really can't create for themselves. So again, just to kind of rehash, a lot of people look at it like creditor protection or divorce protection. But like I said, it can be transfer tax protection, or it could just be a nice hedge for whatever the future is going to bring, right? We don't know what the laws might be in the future. We don't know what each state might do in the future. So it's really just a nice way to give them what I think is a lot of flexibility, even if it's seen as more restrictive because it's in a trust rather than delivered to them outright. So again, I think for, like you said, most of our clients, we sit down and say, you have a $12 million estate, which means in your situation, you don't have any estate tax concerns the way the law is today. But that doesn't necessarily mean just give it to everybody outright, because something might happen in the future that we can't predict. Let's create that protection now so that they have choices as their life unfurls. And then
Kevin,
that
you might comment, sorry to interrupt you. You might comment a little on the HIM standard and just what having something in a trust wrapper, what does that effectively mean for the kids who are beneficiaries of that trust versus getting their property outright?
Yeah. Yeah, and like I said, this is fully customizable. We're going to work with each client, but typically that would be our starting point. So HEMS, as I'm sure most people have heard it, are familiar as the Health Education Maintenance Support Standard, probably considered to be sort of the most broad or gold standard distribution, or what's called an ascertainable standard. But really what that boils down to is, again, we want to make sure we're creating protection from creditors, from taxing authorities, whatever it may be in the future. And so to do that, we have to have certain language and standards in place. And that's typically the most generous of the available options while still maintaining that creditor protection element of the trust. So that's our starting point, but we do have a lot of clients that want to tailor it back from there or provide very specific distribution authority. We may also get into more like unitrust type planning where they might want to have it be a specific percentage over the years, and they feel that that's better. And again, back to the idea of working with advisors, right? So if that helps the investment strategy side of things, we're going to look for kind of a total return and then make a distribution of a certain percentage. Those are all things that we can talk through and make that determination what's best for that client in that situation. But we always just kind of go back to this. The best way to transfer wealth to the next generation is to keep it in this trust so that they really can then decide sort of what to do with the assets in the future. Or the way I always like to phrase it is that way your child or future descendants, they're the ones making the decision when those assets come out of the trust, not somebody else, right? And I think that's kind of our biggest selling point and goal here, to continue to create that legacy planning. I was
There's
going
a lot to explain to kids. How do you find, are you sometimes getting involved in those conversations with the kids or helping advise clients and advisors on how to have those conversations?
Yeah, absolutely. I mean, like Sam alluded to, we're always happy to have people join, particularly maybe that wrap-up meeting if it's the best place to explain that. And I like to think I have a pretty good success rate. I've had several situations where the initial reaction when we talk this through with the clients and then they kind of let their in those cases adult children know what was going to happen. A lot of times there was this, wait, I just want to get my inheritance. I don't understand. And then after having that meeting and talking it through and really explaining that it actually makes things more flexible in many instances, everybody's sold. We do it the way that we were advocating, and people really like it. So yeah, just having that opportunity to really talk it through and even go through scenarios, right? It's maybe they sit down and they start to walk through like okay, so I don't get it. I want to be able to purchase a home. What's that going to look like? And we kind of walk through, well, yeah, certainly support and maintenance definitely includes housing, right? Whatever you need to pay rent or pay a mortgage at the baseline. But yeah, sure, it could be, a distribution to purchase a whole home. But we talk through again, when you've got this protective trust in place and you can kind of interact with it over the course of your life, maybe it's not make a distribution for that home. Maybe it's take a loan from your trust and then you can pay money back into your trust and keep that protection. So again, there's just a lot more options available over the years to structure it in the best possible way. And so again, we really find that given that there are a lot of clients out there that aren't worried about transfer taxes per se, but still have significant wealth because of the increase in those exemptions, this lifetime protection trust can be one of the most valuable tools in really transferring and creating that generational legacy. And I think from the other perspective of the advisors is really, providing a mechanism for which they can continue to provide advice and continue to manage these assets into the future. So we think it's a win-win kind of on all sides of the coin.
Great, Kevin. That's really helpful. And sticking with the whole family dynamics thing, I mean, estate planning is about families, right? That's the business that we're in. And sometimes those family situations are nice, neat little packages where everybody loves each other and is all in on it together. Sometimes those situations, though, can get maybe acrimonious between some children. Maybe there's a child the client doesn't want to include in the plan, and you have to deal with those dynamics. And blended families. My wife and I were a blended family. She's got a child from a prior relationship that's now a grown son. And there are dynamics that come with that attorneys are particularly helpful, I think, at navigating, and especially in the context when they have a financial advisor there that already has that established relationship with the family. Samantha, maybe you can talk about some of those dynamics and how they shake out in practice in the meetings that you're in.
Sure, Alex. Well, going back to those lifetime protection trusts, since they're so popular now, using a corporate trustee until the client feels that their child reaches a reasonable age, we see 30 or 35 a lot of the time, to become a co-trustee with that corporate trustee, learn the ropes for a few years, see how things function, and then once they reach a later age, be able to take over themselves. But if that's not an option, then maintaining that corporate fiduciary throughout the trust's entire administration is a great idea, because they're corporate fiduciary. It's their job to act in the best interest of the beneficiary and be as impartial as possible, rather than having one child sibling manage the trust. And then it's like, no, my brother's telling me I can't have money to buy a new car. So it takes possibility for that familial strife off the table completely. And another thing is, if it's the client's desire and if it's feasible, ensuring all children are created or treated as fairly as possible. So if it's in the context of a business, maybe one child's heavily involved in the family business, stands to one day take over once the parents have passed away. Think about equalization of your assets. Maybe that child gets the business, but the other child gets more cash, another piece of real estate, and then explaining that comprehensively again at family meetings like we talk about. So everybody understands, okay, this is why it is the way it is, and it minimizes hurt feelings as much as possible. And in the case of a child who's maybe estranged, the parents don't feel they're financially responsible, or maybe unfortunately struggle with some substance abuse issues, again, that's best suited for a corporate trustee. And there's also the option to include some incentive provisions within the trust, like maybe a certain amount of time as sobriety, then you get another distribution. So there's a lot of flexibility built in with these types of trusts.
That's great. And then maybe on the blended family front, you all can talk a little about just what we do so I've got a stepson. Now, of course, I want to make sure I take care of them all equally, but what can you as an attorney do to ensure for, say, my wife that that if she, passes away first, some of her assets can end up going to her son.
Right. So that's a way to structure the trust. Again, the benefit of having revocable trusts, so they're flexible throughout your lifetime, but you can build certain provisions in that say, upon the first spouse to die, maybe this part is specifically tucked away for that child and it's unable to be modified in any way. And also, it's another case for upfront family meetings and everybody understanding and being present to see, okay, this is why we're doing this the way we are, and it's helpful, so everybody's being treated fairly and there's no real hurt feelings after the fact. It's knowledge is the best, and transparency is the best policy here, especially with blended families.
Yeah, I always think blended families make a great case for, even if you don't have that significant of assets, those clients need advice, right? They need more than just getting online and answering some questions to get documents, because there are a lot of sort of unknown unknowns that you get that surface when you have a conversation with the advisor and attorney. Thanks for that, Sam. Sort of moving, I think, on to our next question, sort of the strategies that allow clients to maintain control over assets. So, you never want to lose those control, but you also want the benefits of not having control in some cases. So maybe you can talk a little bit more about those dynamics.
Sure. And again, a big part of those is the use of the lifetime protection trust. And since they're part of a revocable trust, they can be changed at any time. So consider maybe when your children are young, there's no real reason that you don't trust them with money yet. Start off with the most broad provisions that you can, allow for the health and maintenance and support, and then eventually the 5% annual withdrawal right once they reach a certain age. And then as time goes on, as they grow up, maybe unfortunately, if you have a reason to be a little more restrictive, maybe you're seeing that they're not the best spenders, then at that point you can think about tightening up some restrictions on the trust. And again, having the corporate trustee there as the neutral administrator beyond death allows for everything to be equal And another great strategy would be using limited or testamentary powers of appointment. So this way the beneficiaries can eventually have a say, okay, maybe I want to appoint some of my money within this lifetime protection trust out to my nieces or nephews or to a charity. But the benefit of that is the client can still be a little bit restrictive and say, okay, you can only exercise this power of appointment up to a certain percentage of your overall lifetime protection trust. So it's still preserving most of the assets for the actual family, but it still gives the kids a little more flexibility to say, okay, if I want to give some extra money to my sister, my nieces, or my nephews, then they can do that too.
Great. So I think now we'll take a minute to look at a case study. So let's look at an actual case study from a client that, of course, we've anonymized for this. Talk through the fact pattern and see what sort of insights you all can offer about it.
Yeah, thanks. I'll jump in and take this one. So, this was a pretty typical scenario that we're seeing more and more, and we'll kind of walk quickly through it, but then I'll just sort of show our approach and walk through it the way we would in a typical, usually what we would call like the initial consultation, just kind of meeting with the clients, explaining, different options that they have. So, early mid 40s couple, they've got still minor children, but children that they probably have some sense of kind of what their interests, goals, and abilities are at this point. We've got the net worth at about 10 million, and they're in Florida, so no tax concerns at the moment. But you'll kind of see at the bottom there, this is a wealthy family, and there's the expectation of a fairly large inheritance on top of what they already have. So, again, kind of like just to rehash what we've been going over, we always want that core estate plan to be in good shape. So this would be a classic scenario of wanting to sit down and make sure that they're going to have, in the case of a Florida couple, we would typically recommend the 2 separate revocable trusts. But with some estate tax planning component, typically it's now the disclaimer approach, right? So we'll have language in there that when the first spouse passes away, the assets would go to the surviving spouse, but they could disclaim them into a B trust or credit shelter trust, depending on what the tax laws are at the time. Or again, maybe in anticipation of some future inheritance, they need to kind of move some assets out of their estate because they're about to receive more assets, depending on what the timelines are here. Again, minor children right now, there's nothing that would suggest that we shouldn't have lifetime protection trusts in the mix here at the moment. So we would set it up. Samantha just kind of alluded to the fact that they're still quite young. We don't know a ton about what their future holds. They're not married. They don't have kids yet. So let's start with a little bit broader provisions in those lifetime protection trusts. But I agree. I do often reference that these are some of the provisions that 10, 15 years from now, those are going to be, mid, late 20-year-old children, and they may be starting their own families, and you may know more about their in-laws and their spouses, and that may mean you want to make some changes to those provisions. And again, we're starting with revocable trust planning here, but also thinking about what the future is going to look like. So just knowing where you can make some of those updates and changes. But we'll start with the lifetime protection trust structure for the kids in this case. We'll have, again, the HEM standard we talked about earlier. We'll have some 5% withdrawal opportunity. And then we'll kind of talk through, what are these clients feeling in terms of who would be the trustee. Sometimes it's an interesting conversation at this stage too, where we've got the minor children. There's going to be a conversation about guardianship and who would be looking after the children if something were to happen to both spouses at this stage. A lot of clients I find it split, 50-50 oftentimes, that should the guardian control the purse strings, so to speak, or should there be some division of labor there? And that dovetails to the trustee conversation, because a lot of times those assets are going to be managed for the minor children through the trust. So who we select as trustee is going to kind of be deciding what's appropriate distributions for the children. And that may involve the guardian, coming to that trustee and asking for certain distributions and explaining, why they're appropriate for the 2 children. On the flip side, there's some clients, depending on their relationship with who might be a likely guardian, that would almost make the trustee decision for them, right? They might say, okay, I really trust these people. They're going to be looking after my kids. I really want them to be able to just make those withdrawals and those determinations, more or less in real time, and decide what's best for the kids. Samantha mentioned we might introduce corporate trustee. That would be a nice way to kind of divide the labor up. Now you've got kind of a professional handling all the investments and working with the financial advisors. And then they're going to kind of make those very professional decisions. And probably a lot of times the way that works, they'll set up kind of a stipend that will always come out. The guardians, of course, would be involved in kind of spending the money still while the kids are minors. But that's another big part of the conversation here, I find. Of course, looking forward, again, at this stage, most people are going to go with 30, 35 and sort of trust that their kids will be adults and mature at that point. So kind of turn over the reins. But back to kind of what I said earlier, the goal is that's still a lifetime trust for them. That doesn't mean all of a sudden all the assets come out. It just means at that point, the child is no longer asking permission for distributions, working with a corporate trustee or working with a trusted relative. They'll start to make their own decisions and their own distribution choices at that time. But they've still got that protection, and hopefully we've educated them on that over the years. I think the other big part of this is just to, certainly address that there are a variety of other planning strategies out there. We don't all of a sudden not do any lifetime irrevocable trusts anymore just because clients may not be as concerned about estate taxes, because we definitely have plenty of clients that maybe their net worth, we have kind of a vague fact pattern here, but let's say one of those assets is a business and it's growing quite rapidly. There may still be a need to move some value out of the estate so that that future growth stays out of the estate. So, again, kind of Sam made a good point. Maybe if there's one child that's ultimately going to be involved in a business and there's kind of a transfer in the future anticipated, we could move that business into an irrevocable trust, make that particular child a beneficiary of that trust, but then offset that gift with some other gift to a different trust for other children in the family. So there's still a lot of ways we can introduce kind of the typical lifetime irrevocable trust planning into the mix, even if it isn't to address estate tax concerns. And then, of course, we have plenty of clients that are still worried about that, whether it's because of a state level transfer tax. So again, introducing insurance planning or just generally using trusts that we can take advantage of gifting into, but then control that those assets are not automatically owned or controlled by the end beneficiary of the children. All of it is still on the table. It's just kind of rethinking the way we mix it together, what's going to make the most sense for each client and their situation, and then just kind of getting the best result. I think the other important part of attorneys and counsel and this day and age too is, addition by subtraction. So a lot of times we'll have clients come and maybe they're in a situation like you're seeing here and I need a slat. I heard everybody's getting a slat. We got to have a slat. So again, we're going to talk through it. We're not going to say no or anything like that, but maybe it just doesn't make sense. There's reasons other people may have done it. There's reasons they may have done it when the laws were more uncertain and now we kind of see what it's going to be, or we anticipate maybe the exemption will be extended or made permanent. And so maybe we're not as concerned about doing that type of planning that someone in their lives had done 5 years ago in anticipation. So we're always just going to talk through, does that additional type of planning really make sense for your situation? Do you understand the control you're giving up? Do you understand kind of the limitations when you do undertake that planning? And is that con offset sort of the pro of what you were thinking about it? So I think that's another big part of our role, is just sort of really talking through all the options, but saying, hey, maybe there's a reason we don't want to do certain things, or we don't want to overcommit to certain types of irrevocable planning, too early on. So again, in this case, we've got, mid 40s, young 40s. I always think clients should probably maintain as much exemption as they can, as long as possible. We'll do planning around the periphery using the annual exclusion gifts. If that's maybe an ILIT where we're funding with the annual exclusion gift, paying the premiums, doing the life insurance planning, that type of stuff. That's usually a nice hedge, a nice middle ground where they're not giving up control of any significant portion of their wealth yet. They're not using up any exemption at the moment. We're in a bit of a wait and see mode because our anticipation is they still maybe have 50 years of life expectancy left. So let's not overcommit to things that then we won't want to unwind down the road. So again, I think this is a great example where, we've got a case where we definitely want to make sure they have some good planning in place. Like I said, having the estate tax planning contingencies in there with the disclaimer, because they're at a threshold where if the sunset happens, for instance, they may all of a sudden really need it at 10 million. But the same thing, if it gets extended, they're in good shape. No harm, no foul. It's in there. If the laws ever change or they ever move, we've still got that flexibility. But we didn't overcommit to certain techniques or strategies, and they're in good shape. So I think that's kind of a typical approach we would take. Turn it
Got
back
some
to you,
follow-up
Evan.
questions
Yeah.
for you, Kevin. So one of those you mentioned using separate trust. A question we get is, why wouldn't it be easier for my clients just to have one joint trust to manage?
Yeah, and again, it could be situationally specific, but our typical approach is that for the clients that are in community property states and they're in a situation where they've largely got marital joint community property, we'll go with the joint trust there because it kind of mimics that particular ownership structure. But in states like Florida, in this instance, where we're not a community property state, we do find that being able to keep it separate, potentially be able to deploy some strategies around the basis adjustment, what's often called the step up in basis. So if you keep it in the separate trust, we know exactly which assets would be assigned to which spouse, so that if they were to pass away, we know which assets are going to get that basis adjustment. So over the years, when you have the two structure trusts in place, we can sometimes move assets back and forth. A little caveat, it's not deathbed planning, but if somebody is less healthy than the other over the years, they may start to move some of their lower basis assets to that spouse's side, so that when it transfers back to the other spouse, as long as it's been with the first spouse over a year, they'll get that basis adjustment. And that may really help the surviving spouse avoid some capital gains, be able to kind of reallocate portfolios, especially on the real estate side of things. If it's a second home or something that isn't going to get any automatic exemption anyway, like the primary residence does, it can be really nice to have that basis adjustment and then maybe able to sell that home or downsize, whatever it is, with having had that structure in place. So it still just gives a lot of flexibility. And then I think the other concern from our seat is always just, well, what if the law changes? We've got a nice tried and true structure in place where we could deploy, AB trust planning and that sort of thing without having to retitle all the assets or do something different that you might have to do in the other situation.
It's great. I got another question from our audience here. Sam, maybe you can take this one, or Kevin, you can comment too. So advisors are reviewing a lot of trusts and wills. It's something I hear a lot. I know there's a lot of action around how can I get my clients' plans reviewed, and that's something we do regularly as well. If you've got a client that's got an existing estate plan, go in, schedule a meeting. It'll be with Sam or Kevin here, and they'll review the estate plan and actually be prepared to comment on it and sort of talk around. And the economics there for us, we're looking for the fact that a lot of this planning happened a long time ago. In many cases, typically there's a multitude of things to be updated in those. But I think the question here is a little different. What sort of language, Sam, would you say advisors should be looking for? Are there certain red flags, or obviously if it's drafted in a different state than the client's living in right now, that might be one red flag. What other sort of things could you note for advisors to look for? Oh, you're on mute, Sam.
And I was muted again. Aside from, again, the state where it was drafted, going over the overall distribution and the disposition of the final assets, making sure that's in line for what the clients still want. Any kind of, maybe that trust was done when their children were younger and implemented a descendants trust. So saying that the money's held for the child until he or she reaches 25, and maybe that's not what the client wants anymore. So just really going through and making sure all the meat and potatoes really of the final administration are properly updated with what the client wants now. And again, maybe that might be amending and restating a prior trust in its entirety. It's just important to know overall if a client especially is coming in and had a trust done a few years ago. And a lot of times we'll see, you know, sometimes they're not sure what's even in it or if they've properly funded it. So it's a good chance to be able to review the overall plan and factor in a prior trust if necessary.
And when you say amend and restate, does that basically mean we can create a whole new trust form but not have to go back and change any of the assets that are already owned by that trust?
Exactly. The assets wouldn't change, but you can essentially change any provision in there that you want. So it effectively does create a new trust without messing with any of the assets that have already funded it.
That's great. Yeah. And on the descendants trust she mentioned, I think the thing to look there for is, are the assets eventually going to the kids outright? What's the end point of the trust for the kids? And if there is an endpoint for the trust, then you might want to consider, you know, scheduling a meeting with Sam or Kevin and taking a look at it, because there's probably, you've heard lifetime protection trust planning a lot through this. That alone would probably be a good reason, particularly if the clients have some significant assets they're going to be leaving to those kids, leaving those assets in a more protected fashion.
And I was just gonna toss into, I mean, we still see mandatory AB provisions, just making sure people understand that could mean a larger portion of the assets are locked up when just one spouse passes away, because that mandatory provision is up to the exemption. So even if one spouse's trust is only 7 million, that whole amount's gonna get locked up because it's below the exemption right now. And if there had been imbalance between the trusts over the years, which we do find, you know, one spouse had the accounts that ended up growing quite a bit. Now that spouse's trust represents, you know, 80% of their total net worth. They pass away. Now it's kind of locked in that trust, when perhaps allowing the surviving spouse to receive some of those assets directly. Again, potentially getting another basis adjustment and things like that. So that's why we tend to advocate more for the disclaimer planning, where you can kind of tailor it to what actually makes sense, and not just force everything to be irrevocably locked up during the life of the surviving spouse. So that's the other big one we're still seeing in some of those older documents.
Awesome. And I think the last question we got is just looking at your crystal balls. What do you think is going to happen with that exemption in the next 6 months? What way's the wind blowing right now?
I mean, I did see some administrative representatives out on the news cycle this morning saying that that's the goal. We're going to get the bill through to expand all the tax cuts. I know there was reference to about some of the campaign promises about like no taxes on tipped wages and Social Security and stuff. So I think they're trying to package that all together, but clearly the message is that they want to extend and or make permanent everything from the original 2017 bill, which would include the estate tax exemption. So, I mean, I don't think the message has changed. I think maybe there's some concern that Congress will actually pass it all so easily. So, you know, I think still probably a bit of a slog, maybe a year-end kind of deal as it usually is. But I would expect to see something where things are extended out a little bit. You know, I know attorneys like to point out other than the year it disappeared, the estate tax has really never gone down from its current level. So, you know, I think they always find a way to keep it or potentially push it up a little bit further, one way or another. So we'll see how it goes, but I still think that's probably likely.
Great analysis. All right. Well, Sam, Kevin, thank you both. Andrea, thank you she's our marketing director, for getting this organized for us. Andrea is going to follow up with an email with a link to recording of this, as well as a link to schedule a demo with one of our relationship managers named Mo. So and in fact, if you want to reach out to Mo directly, you can also reach out to him. She's got his email address up on the screen there. For those that are CFPs, we're going to submit your information to the CFP board for you. And for those that aren't, we're providing materials that's either been sent or will be sent in an email that you can submit to whatever accrediting or educational body you want to try to get credit for on this. We appreciate you all taking the time to meet with us. If you haven't tried out the service yet and you've got a client, of course you got clients, and you got clients that probably need to have some of these conversations we've been having today. Reach out if you don't have access to the portal. If you do, it's as simple as going in there and clicking the Add a Client button, and you can schedule a meeting with awesome attorneys like Sam and Kevin. Appreciate everybody's time, and you all have a good afternoon.